I would also ask that my prepared testimony be made a part of the record, and I'm going to summarize it, but I'm focusing on what the Department of Justice does, which is criminal prosecution.
Without exception.
And I'm going to highlight three parts of that testimony. First, I want to summarize our worker endangerment initiative. I want to talk briefly about two cases which illustrate the disparity between the current current penalties available under the OSHA Act and other statutes, and then highlight three specific areas which I think can be improved. In 2005, the Environmental Crimes Section launched its Worker Endangerment Initiative to highlight the fact that we were finding that companies that were not taking care of the environment were also not taking care of their workers, often resulting in death or serious bodily injury. This initiative requires a coordinated effort with the Environmental Protection Agency, OSHA, and the Department of Justice. I'm very proud to tell you right now, our environmental crimes prosecutors have trained over 2,000 OSHA investigators, EPA investigators, Department of Labor solicitors, and assistant U.S. attorneys in how to find this type of crime. This collaboration now has resulted in some of the cases that I have laid out for you in my prepared testimony, but I want to highlight just two of those because it makes the point that I will try to make later in my testimony. The first is the case of United States versus Alan Elias. Alan Elias was the owner of a fertilizer company in Idaho, and he ordered sludge workers into a tank to remove cyanide-laced sludge without telling them what was inside the tank or providing any protection for them. When one of the workers collapsed in the tank and was taken to the hospital, Elias lied about what had happened, and the 20-year-old employee suffered permanent brain damage. But Elias could not have been prosecuted under the current OSHA statute because the worker did not die. Instead, he was prosecuted under one of the environmental hazardous waste statute and received 17 years in prison. The second example involves United States versus Atlantic States Iron Pipe Company, which is a New Jersey division of the McWane Company. In that case, we argued to the jury that the company had systematically violated the Clean Water Act and the Clean Air Act for years by discharging pollutants into the Delaware River, carbon monoxide, and other pollutants into the air. The company also ignored worker safety laws, and people were injured. Ultimately, the jury convicted Atlantic States and 4 of its managers for violations of the environmental statutes, making false statements, obstructing justice, and defrauding in a conspiracy both OSHA and the EPA. Just last year, the court sentenced the managers to collectively over 12 years of prison. With me today, just behind me, are 2 of our lead prosecutors who prosecuted that case, Deborah Harris and Andrew Goldsmith. It took 8 months, and they are also the individuals who have been leading our Worker Endangerment Initiative, and I'm very proud of those 2 prosecutors. But while our prosecutors have successfully done Elias and Atlantic States, that was really more of the result of the environmental statutes and what we call Title 18 crimes. Those are the crimes that apply everywhere: lying, cheating, and stealing. But they point out the disparity in 3 areas between the OSHA statute and those others that I have enumerated. First of all, as already been spoken to, though the current statute is a misdemeanor, limited to 6 months. And by the way, you could get 12 months if you kill 2 people, if there are successive prosecutions, but that's the only way, as opposed to our normal felony statutes, which have up to 15 years in prison. Second, there has to be a death in order to prosecute, which is totally different than other crimes. For instance, our environmental crimes may be based on a risk of death or serious bodily injury or a knowing endangerment to human health and the environment. Third, unlike most federal crimes, OSHA requires a willful action by a defendant. Court cases describe that as a bad purpose, again, significantly different than the normal environmental standard of knowing actions. Effective criminal prosecution requires statutes that appropriately punish, they deter other conduct, and they level the economic playing field. Measured against that standard, the current OSHA criminal provisions are inadequate. I look forward to any questions that you might have regarding our experiences in these prosecutions.